good morning, New York, and hello to everyone dialing in from around the world. My name is Qian Bao, and on behalf of the New York Arbitration Week Organizing Committee, I would like to take this opportunity to thank all of our sponsors, our financial sponsors, participating organizations, and in particular, FTI for hosting this webinar today. To kick off day 2 of New York Arbitration Week, it gives me great pleasure to welcome the Singapore International Arbitration Center to its inaugural New York Arbitration Week. As many of you know, SIAC established presence in New York last year and has joined the suite of institutions with offices in New York. And today I'd like to introduce the SIAC representative, Adriana Yuson, SIAC's head of the Americas. Adriana oversees SIAC's activities in North and South America and has broad experience as an arbitration practitioner, an arbitrator, and also as counsel in the SIAC Secretariat. Adriana will be introducing to the topic of today's webinar and the esteemed speakers joining us today. Adriana?
Thank you, Qian. Hello, everyone. Welcome to SIC session. We are thrilled to have you all here. Thank you very much for tuning in. We have a very interesting topic for today. Our panelists will be examining what international commercial courts and the Singapore Convention might mean for the future of international arbitration. It is my pleasure to introduce our esteemed panelists for this session. We are delighted to have Ms. Lucy Reed, President of the SIC Court of Arbitration and independent arbitrator at Arbitration Chambers in New York, Mr. Toby Landau, QC, Vice President of the SIC Court of Arbitration and counsel and arbitrator at Duxton Hill Chambers in Singapore, Mr. Hannibal Sabatier, partner at Chaffetz Lindsay in New York, Dr. S.I. Strong, Associate Professor of Law at the University of Sydney Law School, and moderating this panel is Professor Lawrence Bu, member of the SIC Court of Arbitration and independent arbitrator at the Arbitration Chambers in Singapore. Before we begin, I would like to invite you to use the Q&A box to share your thoughts and ask questions. I wish you all a wonderful seminar. Professor Bu, the virtual floor is yours.
Thank you, Adriana. Thank you, Qian. Thank you, everyone, and good morning. For those of you who are in the US and those of you who in Europe, good afternoon. Those of you in Singapore and Far East, good evening. I know you're not asleep yet. Well, in recent years, the term international commercial courts have been mushrooming all over. I understand that there are at least 50 international commercial courts that have been set up. What are they doing? Why are they set up? Why are states setting up such courts? Should national courts not spend their time on national and domestic matters rather than meddling with matters which may or may not have anything to do with the citizens of their own state? So these are questions that I'm going to pose to the speakers today to kick off this discussion on whether there's competition between international commercial arbitration and international commercial courts, as well as the advent of the Singapore Mediation Convention, whether there is a new stream of work that is going to serve as a competition to international commercial arbitration. So why is there a clamor to set up international commercial courts within the national judicial system? What are the motivations behind these states doing so? May I ask Lucy to enlighten us?
Thank you, Lawrence, and welcome to everybody. I wouldn't say that there's a clamor to set up courts from users. I think there may be a clamor to set up many courts from jurisdictions. As with any dispute resolution mechanism, the demand has to come from the users. And in my experience over my career as lawyer and arbitrator, there are many sophisticated multinational entities who tolerate international arbitration for various reasons, but they would like to have the safety net of an appellate review of the, I hope, occasionally very bad decisions or wrong decisions by arbitral tribunals that can't be reviewed on the merits under the New York Convention. They would welcome more transparency. They would welcome expert judges. They would welcome the development of more guidance in international commercial law. and some of the efficiency benefits that come with a national court that's highly skilled in doing international cases. And the London Commercial Court has been around in doing this for well over a century. So to the extent there's a demand for an additional option in international commercial dispute resolution, international courts are being developed to fill it. I think Toby Lawrence who's been appearing in some of the courts more than others of us, would add to my initial thumbnail sketch of the reasons.
Before I ask you to respond or add on, can I just bring up a point that you just mentioned? To talk about, you seem to suggest that there's an appetite by users for international commercial courts. Where does that come from? Is it a survey, or is there just sense from the ground that there's such an appetite?
There's some anecdotal evidence, which I have from my clients over the years, and there are surveys of the desire to have the best of both worlds sometimes, to have the advantages of a real court, a sitting court, a permanent court, and consistency of judges, or depending on the case and the nationalities and the amount and everything else, international arbitration. My point on clamor is that many of the courts, and I don't mean to criticize, but many of the courts that are being set up are more to bring business to capitals and cities than to meet the public demand of users. And my prediction is that only a few of the international commercial courts that are most established and most likely to be around for decades will be successful.
Thank you, Lucy. Thank you. Toby.
Thank you, and welcome to everyone. I entirely agree with everything that Lucy has said. I think I would add to it in this way. I think if you're asking the question, why establish these courts, there are two different forces at play. The first force is that which Lucy has identified, which is a demand from users. But the second one is actually initiatives by host jurisdictions who believe that they will gain certain concrete advantages by having this facility available, whether there are ready users or not. On the first one, in terms of users, I think there's always been a sort of competitive relationship, sometimes symbiotic, sometimes confrontational, between courts and arbitration. There are times where people have gone away from court looking for what used to be called alternative dispute resolution, for something that was faster and cheaper and more efficient than court. And then when there has been disillusionment with that, people have gone back to court, thinking that court processes actually have caught up and they've learned from arbitration and you can get something faster, often cheaper, with actually obligations where performance is compelled, where judges will be disciplined and will discipline counsel. And so court becomes a more favorable alternative to arbitration. And that's an ongoing relationship, which we can probably talk more about later on. But on the second impetus, which is actually host jurisdictions, experience has shown, and many surveys have demonstrated, that having an effective international commercial court in a country brings all sorts of advantages to a jurisdiction. Those are advantages in terms of work for and development for local lawyers, in terms of the development of local law, especially, for example, a commercial court in London, which is regularly developing English law more than any other court in England. In terms of international prestige, and Singapore has experienced that in terms of having a new commercial court which complements other offerings in terms of dispute resolution that the state has, and also invisible earnings. A study was done some time ago in London about the actual inflow of earnings associated with the London Commercial Court, aside from simply lawyers' earnings. And that can be use of facilities, it can be hotels, it can be all sorts of earnings. So I think there's a lot of factors at play, which make this very attractive actually for jurisdictions to have as an additional facet as part of their offerings for dispute resolution more generally.
So your suggestion is that setting up this court is not totally altruistic. Is this for financial, prestige, and economic gain? Is that so, Toby?
Yeah, there are many, many factors at play, absolutely. And all of those are interconnected. And they are, I think the perception is it's for the greater good. It's not just a profit exercise, obviously, but it's worthwhile doing it. And that's certainly, I think, one of the reasons why countries are willing to invest in it.
Well, thank you. Let me see. There does not seem to be a similar interest being shown in the Americas, are there? Anybody? Is there some interest in this area?
Thank you, Lawrence, and good morning, good evening, everyone. Probably in short, no, or at least not now. And probably if you asked some of our colleague judges here in New York, they would tell you that when they sit in a state court or in a federal court, they are de facto sitting in an international commercial court, given the breadth of the issues that come up before them and sometimes the diversity of the applicable laws. And for sure you have in the region more generally some courts which advertise themselves as international commercial courts. You have, for instance, the commercial division in the Virgin Islands. But the reality, especially if you look further south into the Spanish or the Portuguese speaking world, is that there are no self-styled or intended international commercial courts. And that's probably a function of different factors which might change. And that's why I said probably there's not enough interest right now, but we might be seeing courts come up in the not too distant future. And a bit of a sales pitch in this call is I totally see how Colombia or Brazil may come up with something in the next 2 or 3 years. Why aren't we seeing a lot yet? Well, there's probably a deeply rooted, call it what you will, sovereign tendency, kind of localist, assertive tendency by the judges in many jurisdictions in the region. We're talking about the region that engendered the Calvo Doctrine. If some of you have been involved in cases in Brazil or in other jurisdictions, you're probably aware of the limitations to practice in those places. I mean, you need to be a licensed local lawyer to appear before a court. Basically, there's a context that militates somewhat against a court where suddenly people from other jurisdictions can appear, where maybe even the judges are not locals. There's also certainly a bit of an economic component. I mean, if you compare places that have international commercial courts right now, think about some of the Middle East hubs or some of the European capitals, probably they attract more foreign trade than some of the, or than most of the places in the Americas. But that's why I said things might change, and there's really a case for places like Colombia or Brazil, which have been very careful over the last few years to cultivate a culture of attraction to foreign investment, respect for foreign investment and international trade, to become places where you see international commercial courts. And lastly, I think there's a factor that we sometimes tend to neglect, which is that common law is much more of a common law than civil law is, right? I mean, I think even though obviously the law of New York is very different from the law of England, it's still probably closer than the law of Argentina is to the law in France, right? So if you're going to have an international commercial court with foreign laws potentially being applied, with judges proficient in several different systems, you might probably need to be looking for lawyers and judges outside the region. And that would call for a bit of a cultural change, which I suspect will happen, but will take time to materialize.
All right. Thank you. Thank you. Stacey, I think you wrote something about this, some observations about Australia and the US. Do you have something to add here?
Yeah, and I think I'll take it from the kind of the business-oriented front and the perception of the benefits of arbitration more to the constitutional side. And in my study, which was published in AJIL Unbound, so the American Journal of International Law Unbound, which means it's very, very short. It's all of 6 pages. So if you're interested, it won't take a lot of time to read. My analysis showed that certainly in the United States, there is a constitutional problem with creating an independent international commercial court. We do have approximately 21 business courts in the state court systems, but for a variety of reasons, many international parties prefer to be in our federal courts. So to the extent that we are thinking about creation of an international commercial court to compete with the new arrivals on the international commercial scene, we would probably need to be looking at the federal system. Personal jurisdiction will not be a problem. That will just be by consent in most cases. But the issue of subject matter jurisdiction with a specialist twist on international commercial matters could be a bit of a problem. We might want to think about whether it's an Article 1 or an Article 3 court. And there are some exceptions. There are some specialist courts in both those approaches. But the problem is that Congress is loath to create new specialist judges. And that's because there is a general perception in the United States, and indeed in other countries like Australia, that generalist judges are not only competent, but are superior to specialist judges because they have that breadth of experience and breadth of expertise. We in the international commercial context tend to think that a little bit more specialty is useful, which is one of the reasons why arbitration is done so well, because we have the specialist decision makers. So we would have to get past that element. There's also a subconstitutional issue with respect to international commercial courts in the United States, and that has to do with our procedure. Again, many of the listeners will be well aware of the vagaries and kind of exceptionalism of US discovery. And again, this is a major reason why a number of US parties have fled litigation in order to minimize the discovery burden. So parties might not wish to come to the United States if they are going to be subject to Federal Rule of Civil Procedure 26. And finally, the last problem that the United States has experienced is an absolute lack of desire to enter into this market because of a perception that the United States courts are among the best, if not the best in the world. So there is no real impetus to change and develop this new competitive system if we are already perceived as being, the venue of choice for many parties. In some cases, Southern District of New York, I'm a proud New York qualified lawyer, as well as an English qualified lawyer. So I know that the Southern District in particular is fantastic, but I also know that across the United States, that may not hold true. So in the United States, it's a problem of both constitutional law, subconstitutional law, and perception. And some other common law jurisdictions may suffer from that. Australia certainly thinks that it is an excellent jurisdiction, as indeed it is. So there's some interesting kind of pushbacks. And finally, the last point I would make would be linguistic. A number of the international courts around the world have tried to increase their attractiveness by having English language proceedings as a possibility, which again is a factor in international arbitration. The common law courts don't see a need to create that because English is already their operative language. So lots of different points to think about.
Interesting. Thank you, Stacey. You mentioned, I like the term, I noticed the term you used earlier to say that the courts in the US may not be ready to enter the market, and I see if this is really indeed a market, in other words, it's a sale of services, then why not? Why not enter into it and see if this a business that actually is viable in the long run? Let me just switch from there and come on to maybe another question that may be of interest. That is, what do you think it takes for international courts to succeed, or international court system to succeed? What is the positive that people look to? I think Lucy will can probably help us, because she did mention some of this earlier. Can you expand on that? For example, is it the appeal process, the appeal to parties? Lucy?
Thank you, Lawrence, I have a list of factors that I'm sure others can add to. To be successful as a new international commercial court, it will be very important for the host court to have patience and to view it as a very long-term proposition. They'll have to have the long view, if only because access to or use of international commercial courts will, in the end, will be by clause. There will be international contracts that say the venue for dispute resolution will be the Singapore International Commercial Court or London or Court X or Y. There's interim solutions, as they're doing now in Singapore, which is the High Court moving international cases to the court. But it's a long-term proposition, and that means investment has to be a long-term investment. That's one factor. A second is it's very important, in my view, to have a truly international commercial bench, to have not just the judges on the local court who are going to be very experienced commercially, but also judges of other nationalities, civil and common law experience. Stacey, we can come back to this. I don't think offering your national court system just in English is necessarily going to attract a lot of users. The rules have to be carefully written, as they always are, the rules of court, but they need to be accessible to foreigners. There is a lot of idiosyncrasy in national court procedural, and I'm not talking evidence, but just how to use the court. So the courts need to think about access. Another is, and this is related to longevity, people will watch the track record. They will want to see public judgments, even if they're sanitized for confidentiality, which happens anyway. They will want to see that the international judges are not just first instance, but are included at the appellate level with the national court judges. They're going to want to see stability. They're not going to want to see the bench turning over regularly. And they're going to want to see that it's cost effective for them, of course. Each court can set its fees in different ways, and that it's efficient, that the judgments or the awards or the decisions come out quicker than they might in international arbitration. And lastly, I probably should have put this first. Courts are not known to be that flexible. They have long traditions, they do things a certain way, but an international commercial court has to be flexible in terms of allowing the parties to customize the procedure. There should be opt-ins and opt-outs in the rules. For example, confidentiality. The Singapore court allows the judges, I'm not sure it's happened yet, to adopt a foreign set of rules of evidence if the parties want it. It takes all those factors, but I emphasize the long-term patience of setting up a new court and having a proper population of users.
But based on your list of points that you have just made, I can see there are a lot of commonality between arbitration, international commercial arbitration, and international courts, except maybe the appeal process and that there's a permanent bench. So wherein lies the difference? How should parties choose and differentiate between the two?
Well, it will be case by case, sector by sector, experience by experience. Many parties who choose arbitration, obviously, because they want to select their 1 or 3 arbitrators. You can debate whether there's a right to do that in international arbitration or not, but they're happier with picking their own judges or having an appointing authority do it. The cost of that is there's not predictability, as there is with a bench where judges are signing opinions and one can predict perhaps better where they will be going as they develop and harmonize international commercial law.
Yeah. Well, the other item that may be interesting, which maybe Toby you want to jump in, and that is, I just
wanted to add to that. Yeah, I think it's important when we talk about international commercial courts to understand, of course, there are different models that are quite different, actually. So you can't really compare the English commercial court to the SICC. The English commercial court is a national court. It's simply a division of our Queen's Bench. It's a high court. And it's been there for an awful long time, but it has become an international forum. It's still, however, populated just by English judges, and you have to be a member of the English bar to argue in front of it. It happens that actually 80% or more of its users have got no connection to England whatsoever. And that's just because it's built up an international reputation. Now, there are other courts around the world that are trying to do a similar thing by, for example, just switching to English. It may still be a local court, for example, in the Netherlands or in Germany, but it is now just internationalizing itself. That is completely different to, for example, the SICC, which is set up as a mixture of Singapore judges and international judges. It's completely different to DIFC or to the Kazakh model or Abu Dhabi. And I think one can't sort of just merge them all into one. They're different. And so I think when Lucy says, for example, there should be a truly international commercial bench, that is true in one model, but not all very successful commercial courts have that.
Thank you. Thank you. Yeah. Actually, the question I was more interested in that Lucy brought up, maybe I'll ask Anibal for his contribution, and that is the appeal process. Does the appeal process actually appeal to parties?
Sorry, Lawrence, I missed part of the question. Would you mind repeating?
Yes, my question is whether the appeal process, which may be available in international commercial courts, does that really appeal to parties?
Well, I think it does, and it's probably one of the strong selling points about the whole system, right? Probably one of the downsides of international commercial courts that we'll be talking about in a minute is enforcement. They are not backed by a treaty like the New York Convention, which backs very strongly the enforcement of foreign awards. But the International Commercial Court offers you something that arbitration may not offer you. There's the predictability that Lucy alluded to in the personal component. I mean, you know from the beginning who the judges are that you're going to be appearing before. That's not the case typically in arbitration. You submit your request for arbitration and all you know is whom you've appointed or whom you're likely to appoint. And I think appeal goes to the same point on predictability. Arbitration in many respects, I think, has been the beneficiary of a huge windfall during the last few years where international trade grew exponentially, and frankly, arbitration was the only, or at least the most readily available dispute resolution mechanism. That doesn't mean it's a natural for all disputes. It doesn't necessarily mean it's always best for all types of disputes. And there are disputes which are very sensitive for the parties, be it because of their size, because of the reputational component, because they may snowball into other cases. If I lose this case, I might be sued by some other terminated distributor or some other similarly aligned party. And those are cases where the parties typically are not looking just for expedience in the outcome. They're looking for a really well-grounded, solid legal decision adjudicating the dispute. And arbitration can provide that. I think most rules are well equipped to lead to that result, but you're still very much in the hands of the specific tribunal you end up appearing before. And the reality, let's face it, is it's a one-off. I mean, you win or you lose, there's no review. Those of us practicing here in the US are used to reading federal court rulings saying, on set-aside actions against awards, saying, I may personally disagree with the outcome of this case, but the Federal Arbitration Act bars me from setting it aside just because I think it's poorly decided. You can mitigate that when you're before an international commercial court, if the International Commercial Court provides for the appellate mechanism. You can fine-tune, or you can expect the decision to be fine-tuned to the satisfaction of users who have a need for a well-crafted ruling, for sure.
Well, looks like there is some majority view here that the appellate process is good and appealing to end users, in which case shouldn't we then consider, for example, asking the president of the SIAC to introduce an appellate system within SIAC? shouldn't the arbitration institution then come up with an appellate tribunal as well? Stacey, do you have any views on that? Oh, Annabelle?
There are institutions doing that. Here in the US, CPR and the American Arbitration Association offer appellate protocols. There's still an opt-in, but it's going to be very interesting to see long-term with they become built into permanently into some rules. But I think there's a sense that for a certain bracket of disputes, users are willing to trade speediness in the disposition of the case for predictability and quality in the ruling, for sure.
Yeah, Stacey,
I would agree with
yes.
Annabelle. One of the things I would note is the desire for an appeal certainly is strongly felt by many parties in arbitration. One of the things that I found most interesting when I was doing research back in the day on class arbitration and the whole rationales of why people were trying to go back to court instead of staying in class arbitration, which actually is much better for parties in many respects, was this desire, this at least alleged desire for an appeal. If you look at the statistics in the class action, class arbitration front, defendants, which are the ones, they're always the repeat players. They're the ones who are making the biggest stink about being in arbitration. Defendants lose much more often on appeal than they win. So rationally, they should want to be in arbitration. They should want to avoid that appeal because it's going to increase their costs and it is not going to increase their likelihood of winning in any way, shape, or form. However, as Lucy and I have talked about this on numerous occasions, the rationales for both the legislative as well as individual processes with respect to the class suits is very tactical, and it's not about due process. It's not about this grand desire for an appeal. It's about winning, and it's about stopping the suit altogether. And that's why the move back towards bilateral arbitration. The other thing that we have to think about with respect to the concept of appeals is a psychological phenomenon known as the status quo bias, and the concept that people are more familiar with the system that they know best. And for a lot of parties, the system they know best is litigation, and they are used to that appellate process. And so there's a strong emotional need to replicate that particular system in arbitration, which is why we have the CPR Institute and the AAA appellate process. I'm not saying that parties, again, don't want to avoid those bad decisions in arbitration, which hopefully happen far less than some parties think happen. But we have to think about this cognitive distortion of the status quo bias towards litigation.
I just pick up on one point there, Lawrence. I think that's a very, very interesting point that Stacey makes about status quo bias. But actually, there's a phenomena, I think, in the development of commercial courts, international commercial courts, where that bias is also in play, because countries are setting up commercial courts in a way that will be recognizable in order to attract users. And that means feeding into what they already expect. The downside of that is that we are, I think, therefore, replicating the English commercial court in many countries, often when it's entirely inappropriate. And that itself has had mixed results and often sets up all sorts of tensions if you somehow implant the commercial court with English retired judges in the middle of a jurisdiction that's got no relationship or identification with that process.
All right, thank you. Lucy, will SIAC, without non-binding expression of view, you think SIAC will set up an appellate tribunal?
No.
Appellate process? And why?
No, no, I don't. I think, as someone has previously said in this webinar, we have to be careful when we're thinking as very experienced practitioners and arbitrators about the big cases, the big high stakes cases, lots at issue, lots of politics that make some of us think about the benefit of an appellate safety net. The vast majority of commercial arbitrations, in my experience, are relatively small. The parties want it done, want the decision done quickly. An appeal might be a protection, but it's also a sword. It's also a tactic that can slow things down. So I think that the Singapore International Arbitration Center and any international arbitration center should stay an arbitration center. I like the idea, maybe an optional protocol for a secondary review. Certainly investor state, we're up to here with second instance appellate bodies. But no, I wouldn't be recommending to SIAC that they set up an appellate
just
level.
throwing in just for discussion and see whether there's any appetite or suggestion. Anyone gets seduced by the appeal of in the arbitration process. Well, there's a question that's been posed, and I think it also leads us to the next question that I was thinking of, and that is issue of enforcement. Will there be a question of enforcement when it comes to the judgment of an international commercial court? Is it easier to enforce or less because there is no New York Convention in this instance, in such a case? Stacey?
So I think one of the things to think about is whether the Hague Judgments Convention is going to have any legs at all. And that, of course, is we used to have the $60,000 question in the United States. Now it's probably the $60 million question. This concept of enforcement and how to compete with arbitration has been one of the primary motivating factors for the Singapore Convention that we're going to talk about later. I was involved with setting up the initial proposal for the Singapore Convention, and I conducted what's called a dispute system design analysis, which looks at the entire legal environment. And I saw that there was a missing component. That missing component of a multilateral convention with respect to enforcement of judgments has long been missing, but it's now here. However, it has not gained the type of immediate response that the Singapore Convention has. And I think that is going to be a bit of a problem for these international commercial courts when the assets are not already in that jurisdiction. With Singapore, there are a lot of multinational countries or companies that have some connection pre-existing to Singapore, and therefore there can be immediate attachment within that jurisdiction without the need for international enforcement. London, as Toby said, the London Commercial Court also has had some benefit in that regard, although there are many, many parties that have no connection to England whatsoever. So I think looking at the Hague Convention issue is going to be important, and thinking about what kind of commercial center that international court is already. That's why perhaps some of the German permutations of these international courts might work, because there are so many financial connections to Germany already.
Good. Annabelle, anything to add to it?
Sure. That's going to be the defining question for the international commercial courts, right? I mean, it's not like their judgments are not enforceable right now, but the enforcement is less predictable. In the US, for instance, you don't have a federal statute governing enforcement of foreign rulings. You're basically depending on state statutory provisions and the common law. If the Hague Convention really garners momentum and ends up entering into force for a wide number of countries, things would change, and you would have a more reliable and predictable framework. It doesn't mean, however, that with the existing framework, international commercial courts are completely vulnerable or of little use. I think Lucy was angling at this with her prior remarks. There's a wide variety of users and there's a wide variety of cases. In the current system, and in talking every now and then to users, a little bit less now because I'm no longer with a big law firm with a transactional practice where people are drafting ADA clauses, but my mostly anecdotal experience is that there are still cases where enforcement is not the driving consideration for the parties. They know each other well. They're big companies. They cannot afford to defy or default on a ruling from a well-established body, be that Singapore International Arbitration Court award, be that a Dubai International Financial Center judgment. They're going to comply with it because they also need to reassure their shareholders, their lenders, that they are in good financial condition, that they are fair players in the market. But still, the number of cases in that situation, the number of cases where really for the users, enforcement is not a critical element, remains a minority, right? So unless you end up having a reliably strong enforcement component worldwide, there's a chance that international commercial courts might stay limited for a certain type of cases, big company to big company, which don't make up for the majority of international disputes nowadays.
Thank you. Yes, Lucy?
I just want to add to something Anibal just said, which is that we know that the vast majority of arbitration awards and court judgments are voluntarily complied with. But whenever any great champion of international arbitration wants to attack the competition of an international commercial court, they say, oh, enforcement, there's no New York Convention. I think everyone on this screen and probably and many in the audience have seen how hard it is to enforce under the New York Convention in a case where the losing party does not want to pay and will hide assets and be chased and chased. So it's too easy, I think, to say it all turns on the New York Convention and on enforcement.
Some of us make a living out of defense.
Well, I think
Lucy's gone over to the other side.
I want to quickly move into the Mediation Convention that Stacey spoke about earlier. I think it really came in as a great fanfare with 46 countries signing on to it when it was launched, and now we have 55 states that have signed on to it, with 8 ratifying it. And it's a convention that took the world by storm, actually, in that sense. And given the number of parties that have signed on to it, I think it will be one of the most well-followed, signed on convention in history. Do you think this convention will change or affect how international arbitration will develop in the years to come, Stacey?
I think I don't know if it's going to change how arbitration develops. We've seen a lot more step clauses involved in international commercial dispute resolution provisions. And I think that, in fact, I know that was part of my motivation in undertaking the initial study that eventually led to the US proposal to Untitled. There's already an appetite amongst parties for mediation as an option, not necessarily that they're going to go that route. They want to have it as a possibility. And that was the intent of the Singapore Convention, not to elevate mediation in any way, because there are a lot of people who dislike mediation. And as I was saying on our planning call, I used to be one of them. I am more naturally adjudicatory in my outset, win, lose, let me just take it to the court. I don't want to negotiate. But there are a lot of parties who are the opposite side. So with respect to the Mediation Convention, it's going to put things on a level playing field. It's going to reflect that shift, the existing shift towards step clauses. And it's not necessarily going to force people into mediation who would not already be there, but it might legitimize the process for those who are dubious. And that was a point that our colleagues on the panel made, and one that I think motivated UNCITRAL in adopting this provision. I could go on and on about this, but this is supposed to be a panel, so I will open it up to the other folks. Yes.
Toby?
Yeah, I think it's interesting to see to think about what the effects of the convention might be. The cynics say there's no need for the Singapore Convention because if parties are minded to mediate in the first place, they will be minded to comply with the result of the mediation. And so why do you need a formal New York Convention style procedure for recognition and enforcement of the mediated settlement? But I think beyond that, and what Stacey is pointing to, is that the convention may well attract people to mediation that would otherwise never have gone to mediation. Those are the people who would ordinarily want to go for a final form of adversarial dispute resolution like arbitration, but they're disenchanted with the cost and a delay of arbitration. So now with the Singapore Convention, you have a new form of dispute resolution, which is mediation leading to a final and enforceable result. And that might actually siphon off the people who are dissatisfied with arbitration and make mediation now a new form of dispute resolution, which you go into and you participate in it with a view forcing the other side to actually comply with the end result. And I think that then will be competition. If that happens, it'll be competition for arbitration, because it'll be those parties who otherwise, if arbitration had been better, would have been there.
Maybe I should add the word for the sponsors, because it's SIAC that sponsored this or organized this. I think when you meant competition for arbitration, you meant non-SIAC arbitration.
By definition, that goes without saying.
Of course, I include ICC as well. Well, we want to also ask some, Annabelle do have some views on the convention, mediation convention.
Sure, and picking up
negative ones, I think you have.
Sorry?
Negative views, right?
No, not necessarily. It's more than any other thing. It's maybe just reminding our listeners that it's still in its early stages, right? And you were asking, will it be a game changer? And I think, or is it a game changer? And I think the short answer is yes. I completely agree with what Stacey, Toby were saying. The big question is when will that change materialize? And I was reminded the other day at our planning call that there were even countries in Europe, I'm thinking of Italy, Portugal, Spain, where the first enforcement actions over New York Convention awards only came in the late 70s, early 80s. That's a good 20 years after the New York Convention was opened for signature. Things have changed. There's a much more vibrant international trade nowadays. We may not need to wait that long, but it's going to take a while, certainly, to see how the Singapore Convention is applied. It's a well-crafted convention, but it's a convention that's a game changer in many respects. Sometimes when you just read the newsletters coming out when the convention was open for signature, there was a lot of emphasis on how the convention tries to replicate the model from the New York Convention, which it does to some degree, but it also allows for a standard of review of the settlement agreements that's simply inapplicable and frankly broader than that set out in the New York Convention. I mean, the Singapore Convention allows the judge to review whether the obligations agreed to in the settlement agreement are clear, whether they are comprehensible. When it comes to due process, there's a very interesting standard. The judge can deny enforcement of the settlement agreement if there's a violation of mediation standards, and without which the party who breached would not have entered into the settlement agreement. So not just any violation, but one that would have led, one that was so material that it was decisive as to whether or not the settlement agreement was entered into. These are broad provisions, and we need to see how the courts apply them. And we sometimes forget not only how instrumental the New York Convention was in changing the landscape, but also how instrumental practitioners were in changing the landscape. I see on your library some ICA yearbooks, Lawrence. Well, the yearbook of international commercial arbitration that Peter Sanders and then Albert Jan Vandenberg came up with, collating and discussing New York Convention opinions and trying to come up with uniform standards. Albert Jan Vandenberg's New York Convention commentary, trying to do the same. Those were pretty much instrumental in setting up a level play field. And we're going to need something like that before the Singapore Convention gives its whole potential.
Thank you. Yeah, you're not negative at all. I'm so happy to hear that, because I'm a great champion of mediation. I love mediation. I think it does not challenge arbitration at all. It complements, in fact, in my view, because it's all part of the process of dispute resolution for international commercial disputes. It's wonderful to have such a development. As a matter of practice, I always have actually a window for parties to consider mediation in the procedural order number 1. Hey, so Lucy wants to say something.
Just want to say quickly, it's important for us to step back from the Singapore Convention and acknowledge that mediation domestically is very well developed, but international mediation is not that well developed. And there's not a very big pool of experienced and responsive international mediators who really can mediate cross-cultural and legal borders. I think one of the biggest benefits, and I've said this many times, of the Singapore Convention is the halo effect of calling attention to international mediation, the way the New York Convention called attention to the possibility of international arbitration. I don't think enforcement is going to be, is the biggest impediment to international mediation, the way probably enforcement was more so for international arbitration, but it says international mediation is important and it's here to stay. And we'll be promoting more investment and training and use and thinking about international mediation.
There's a question that has been posed here. He asks, is there a danger that a mediated settlement agreement within the scope of the Singapore Convention might be more susceptible to being unraveled or tactically challenged than one that falls outside the convention? In other words, because there's a convention, because there is an instrument, now there are grounds to see whether you can challenge its enforceability. So the argument is the other way. The absence of a convention may be better. Do you agree with that? Yes,
I would say I did an empirical study on enforcement of settlement awards on a cross-border basis at the very beginning stages of the trial process, because the delegates were not sure whether there was a need for the convention. And my survey was published in the Washington Lead Law Review back in, I think, 2016. And there were a series of questions. One was, how easy is it to enforce a settlement award arising from mediation in your home jurisdiction with all domestic parties? How easy is it to enforce a settlement award generated in your jurisdiction but needs effect in another jurisdiction? And then how easy is it to enforce a settlement award, I keep trying to say arbitral award, but settlement award in your jurisdiction that has international barriers? And the difficulty level increased exponentially through those series of 3 questions. And this was a very big international survey of practitioners specializing in commercial dispute resolution. So I feel that the responses are robust for what was trying to be sought in that particular question. So the concept to me of, is it going to be easier to deal with awards, settlement awards that fall outside the convention, is really a bit of a misnomer, because I do have some empirical evidence that that was already a very, very hard thing to do. Maybe not in all jurisdictions. Again, as Toby has said before, we have to be very careful about broad brushing about any dispute resolution mechanism. But it is concerning to me that there is this thought that it would be easier outside the convention, because the empirical evidence says it's hard.
Yeah.
Lawrence, can I add to that?
Yes.
I think just from, if I can have my jaundiced perspective of counsel, the convention, like any other document, of course, raises all sorts of possibilities for argument, like any charter. And it's Annabelle's point about how long it's taken for the New York Convention to settle down. There will be, of course, many arguments now generated by the language of the convention that you wouldn't have without the convention. So I think the point that's being raised is a valid point. And the hope is that it doesn't, the system doesn't succumb to lawyers being overly technical and courts being being confused by this.
If I could rebut just one thing to think about, and I think the points have been made here that the Singapore Convention is significantly different than the New York Convention in some ways, just because mediation is different, and so you needed to have different standards. And some of us fought back against some of the provisions which have been mentioned here, but there are a number of provisions that are very similar to the New York Convention. And so my thought has always been that there will be the benefit of the established judicial pronouncements on certain concepts, and that in all likelihood, I don't have a crystal ball, in all likelihood, those will translate over to both the Judgments Convention as well as the Singapore Convention. So there will be some uncertainty, and definitely some of those more novel provisions are going to take a while to settle down. But it won't be like the brand new world of the New York Convention in 1958 or in the 1970s when people started to actually sign on to it.
All right, good. Thank you. Thank you. There's another question here. Going back to international court. Sorry, Annabelle, you want to say something?
Yep.
No. Okay. And then it goes like this. Why would parties to an international contract choose a permanent court, a permanent international commercial court over an arbitral institution to settle a dispute? It seems that a permanent court and the predictability it could bring may take away the plasticity, I think we meant elasticity or easiness of the current system or flexibility of current system. I'm not sure choosing the permanent court will always be the best option for my client. Can anyone try to?
I would happily
Yes.
jump in. Happily jump in on this one. The idea of arbitration, of plasticity or elasticity, is of course one of its selling features. But I'm afraid that that kind of elasticity shades in quickly to flabbiness. And it shades in to tribunals suffering from due process paranoia. And it shades into processes that are just undisciplined because everybody is now petrified of telling counsel to stop, or saying to counsel, this is not helping me, or saying we do not need this procedure. Because even if you are convinced you don't need the procedure, you will be sowing a possible future challenge. And you don't know where that challenge will be. It could be in a country that is less experienced than other countries. So you play it safe. And playing it safe is something which actually now distinguishes arbitration from court. When you go into court, it's very refreshing now to be screamed at by a judge and told your cross-examination is irrelevant. Stop. I'm not letting you continue. Or saying, I'm not going to let this evidence in. A tribunal will very rarely say that. They'll say, well, we'll just let it in and we'll decide about weight later. And so it's that discipline, which I think one gets from courts, commercial courts, that can actually speed up the process and reduce costs. And it's also that discipline, which, because this is cyclical, this relationship, it's that discipline that arbitration is now learning from, relearning from again, because people are trying to come back to it with new rules in arbitration for early dismissal, for example, or expedition. So both processes learn from each other. And I think at the moment, the increase in commercial courts is telling us something about what's wrong with arbitration.
And I think,
sorry.
I would just say a short answer to that question is to step back and say, why would companies want to choose national courts for dispute resolution, which is the first choice of most companies, big, small, or medium size. But they can't when they're doing something cross-border. So there's just always been a default to international arbitration. To have some good, solid international commercial courts will add an option. They're complementary. They're complementary, and so it will depend on the viewpoint and the knowledge and the education, if you will, of in-house lawyers as to whether they choose international commercial court instead of arbitration or instead of national court.
Well, if you choose arbitration, make sure you choose the good institutions like ICC and SIAC. I think that must be the answer. Least minimize mishaps. There is another question this time, I think, for back to mediation. Do you feel that prospects of mediators being called as witnesses in proceedings to challenge international mediated settlement agreements will have a chilling effect on the growth of mediation? Annabelle?
That's a good question. I'm speaking from memory. I think that there are mediation rules around the world that already set out the mediator's immunity in terms not unlike that of the arbitrators, which is something to be considered. And of course, I would imagine a prudent mediator could always build that clause into their retention agreement with the parties. Going back to the point Stacey was raising before, it hasn't become a pervasive problem with international arbitration awards.
Right.
Very rarely do you see courts calling the tribunal, even having the power to call the tribunal. I would imagine the same rationale would continue to apply here, especially because the mediator is also not a decision maker. He's just a facilitator. And I think there's a critical difference there in that the parties still willfully enter into the settlement agreement that they signed with the mediator, whereas the award is more of a received instrument, something that they may disagree with. But it is an interesting question, and it certainly leaves me thinking. I think my off-the-cuff answer is I don't think why that should happen, but it's certainly something to ponder. Of course, if mediators are exposed to testimony in court, that will pretty much be a significant hindrance in the system and a compelling reason for people to maybe not want to choose it.
I agree. I think chances of mediators being asked to appear in court relating to a mediation will be a breach of the confidentiality undertaking given by the parties. Yes, Stacey.
One of the things that we thought about when we were drafting the convention in the Untitled Working Group 2 is kind of the quality of the award, the settlement award. And certainly there were forces within the mediation community, which, as Lucy said, is primarily domestic, but there were still massive concerns that the convention was going to create an overly legalistic or an overly formalistic approach to mediation. And I hear that, and I can appreciate it, having seen the evolution of international arbitration over the course of my career. But there is something to be said about how A, the fear of being called, but B, the fear of a challenge award or a challenge proceeding might improve the drafting of the mediation settlement agreement. Basically, you know, the problems that would arise would be from lack of clarity, and either the parties doing the drafting themselves or the mediator assisting in the drafting. Because the other thing we learned is that in different communities in different states around the world, that process differs significantly. The role in which the mediator takes part in the drafting of the agreement can vary significantly as a matter of law. Sometimes mediators are permitted, sometimes they are required to either be involved or not involved. So the creation of a higher standard with respect to the content of the mediation agreement, or sorry, the settlement agreement. It's 2 o'clock in the morning here, and obviously I'm just hitting the wall. My cup of tea has run out and I can no longer form sentences. But I do think that there's that concept that the potential burden of testimony might improve the content of the award. The other thing to think about is that many of the types of disputes that will arise with respect to a settlement agreement will not have anything to do with the content of the award. It will be subsequent performance. Have the parties complied with the forms, or whether they have the money, all sorts of different elements which are not even going to implicate the mediation process, and therefore will not implicate the mediator arising as a witness.
My view, of course, to say if you ask me, I would say that the risk is the same whether there's a convention or not. If a party wants to drag mediator to court or an arbitrator to court, they will do so. Whether or not the mediator is liable or not, they will not care. It does not matter to them. They'll just put your name in as defendant and you'll be brought to court. And of course, that inconvenience the mediator or the arbitrator, and whether with or without a convention, this can't be avoided. Yeah, good. What other questions? I think we ran out of questions from anybody. Yeah, let me ask if there's anything else we want to discuss, and that is finally, I would think maybe is how do we overcome this competition? Is this, how do you see this competition between the courts and arbitration and mediation, international mediation? Is this healthy, or is it going to be like the US and China's kind of competition? How do we see this thing moving ahead? Anyone?
I think it's healthy. I think it's good. I think ultimately the point is something that has already come up in the discussion today. There's a market realization that arbitration, good as it is for so many different cases, is not necessarily good for all cases, and there might be there's both benefits in having choices, and as Tavi was suggesting, there's also a benefit in the competition in that there's some cross-pollination in terms of practices. And I completely sympathize with the point that Toby made about how an experienced international commercial court is more likely to take a decisive approach to unnecessary evidence and be valid guidance, be a good example for tribunals, arbitral tribunals realizing the courts are doing that, why don't we? I mean, what's preventing us from being assertive when we should be? It's going to be a long process, and I think it's still too early to tell exactly what the outcome will be. We keep talking about arbitration and its growth as if it were something that exists uniformly everywhere around the world, and it is true. I mean, something quite fascinating about our practice is that, I mean, someone from New York could appear tomorrow in a case in Singapore or Sydney and be quite conversant on the categories and the forensic techniques expected by the parties and the tribunal. But in many respects, I think the practice of arbitration remains heavily regional. There are still significant fragments and chunks of the practice which are not always easy to coalesce. There's still regional practices, both in a case where the parties want the positions, and we're going to have the positions. One of the parties wants the positions. That would really make European practitioners hair stand up. There are companies coming with very different interests to mediation. I've seen companies, to arbitration. I've seen companies that arbitrate mostly distributor and agency disputes. For them, consistency is critical. If they lose with a distributor, with a terminated distributor in Hong Kong, they want to make sure our distributor doesn't know about that or cannot use a similar theory to sue them, right? That's a very different user from your shipping company that's just trying to collect the charter fee, right? So I think the variety is quite useful in that it caters to people who come to the system with very different needs, and it's good to have the power to choose, even if you can't always expect exactly the same solutions wherever you go.
Thank you. So more options, more access to justice, and therefore it should be good. That's a conclusion. It seems that Anibal, you have reached. Is that correct?
Yes. Thank you.
Good. I have never appeared before International Commercial Court, but I'm sure there's distinguished members, eminent lawyers here have done so. Toby, you must have done so. Can you share with us your experience?
Yes. I have done frequently, and I've appeared before many different types of international court. And it is a very, very interesting, very valuable experience, I have to say. And if I were to pick on some of the distinguishing features, I can think about in particular the SICC in Singapore, where I have appeared before a mixed tribunal. That is a court of 3 judges, where the presiding judge is a sitting High Court Singapore judge. One of the other judges is French, and the other judge is Indian. And the issue was an application to set aside an arbitration award. And what was fascinating during that was the range of perspectives coming from the bench on points of arbitration law, on points of philosophy towards arbitration, the kinds of questions that were raised, and the procedural approach. I've had a similar experience in sitting in front of, for example, also in the SICC, an Australian judge as a sole judge, and realizing that the procedure was different, the assumptions were different from just a Singaporean or an English judge. So there's great value, and there's a great sort of richness one gets from that experience in that environment, which is something one gets in arbitration as well. But I think this is it's a great merging of the two in an international court.
Interesting. Where then is the consistency then?
I'm sorry?
Where then can we find consistency or predictability if the bench keep changing?
You can overall, but I'm not sure that, I mean, sometimes you're looking for predictability, for example, on substantive law. So if you're applying, if the SICC is applying a particular law, you would be hoping for predictability on that. But procedural predictability is not something which necessarily is a good thing. It may be that you want innovation.
Okay, good, thank you. Lucy, anything to add to that?
No, I really don't have anything to add to that. I think that it's healthy. It's healthy for international parties to have choices. I'm hoping to see a lot more use of mediation internationally myself in general, just because it's good, better to settle. And there'll be this tailwind, I think, from the attention that the Singapore Convention has given us, but also for what Toby said, I think at the high level, international arbitration has gotten a bit, not more than a bit, can be very undisciplined, and people are disappointed with it. And therefore the competition will help on the discipline front in international arbitration. And let's not even get into investor state and the multinational courts and all of that.
Thank you. I should add that, of course, SIAC has a protocol that enables parties to commence arbitration and then go into mediation. And thereafter, if there's a settlement, it becomes an arbitration award without need for use of the Singapore Convention. And if there's no settlement, then the arbitration continues. So it is a model that has been used for a few years, and there are some cases that have gone through that system, that protocol. Of course, with the convention coming to force, they may have less relevance in future. But until then, if people are uncomfortable to go straight into relying on the SG Convention, because there's only 8 countries that have ratified it, but I'm sure it will snowball in time to come. But until then, you still can use AMA, a protocol of the SIAC. Well, time is about there. We have only 3 minutes left, unless some fellow speakers, I think there are no other questions that I think we need you to attend to. I will announce I was asked to announce to the attendees that the CLE code is ARB 675. ARB 675 is the CLE code that you have to sign on the form that has been given to you. And I hope I don't have to repeat that. Maybe I do it one more time. ARB 675. Final words from our speakers. Just a 3-second mention of anything. Yes, Stacey.
Just the one thing to think about with respect to competition. I think we all, again, on this panel, we are used to the really big parties, really big cases and disputes. And we have to remember that not all disputes are like that. One of the kind of innovations that we've seen over the last 20, 30 years has been the diversification of the types of parties who are involved in international commercial transactions. It's no longer the big multinationals only. It is now literally the smaller mom and pop companies that are using the internet and therefore engaging in international commerce. So for them, having these different options, whether it's national court, an international court, international arbitration, or international mediation, is really, really important. The question, of course, is whether they're going to be aware of all of these situations and whether they're going to be able to include those in their transactional documents at the beginning, of course, we all know you can come to an agreement afterwards about whether to go to arbitration or mediation, but a pre-dispute clause is better. But for them, that kind of choice is incredibly important because they just don't have the money to engage in the kind of never-ending large-scale litigation / arbitration we have today.
Thank you. Annabelle?
I don't know that there's much. I don't know that there's much to add to what we said. I think it's a nice time. It's a time full of choice. It's also a time for conscientious choice, and it's a challenging time in which we are at the crossroads of building what the system will look like in the next 10, 20 years. Will mediation become more prevalent? Will the Singapore Convention work out? Will international commercial courts become a standard alternative to arbitration? Pretty much depends on what will happen in the next few years.
Thank you. Thank you. I think when with more and more international commercial transactions with and trade, there will be more disputes. There will be all kinds of options for dispute resolution, and this can only be good. I see the competition as healthy. I don't think it's destructive of one or the other. And therefore, I think this discussion today has been most fruitful and encouraging. And I thank everyone for attending this session, for keeping time, the panelists especially for keeping very good time and responding to the questions. I hope it has been helpful. It has been helpful to me, and I hope it has been helpful to you. Thank you very much for joining us. I will hand this time back to Adriana. Adi?
Thank you, Prof. Thank you very much to our panelists. That was a really interesting and engaging discussion. Thank you everyone for tuning in. Please join the other events throughout the New York Arbitration Week. Have a good day ahead. Bye.
Thank you.
Thank you.
Thank you.